Bismillahirrahmanirrahim. Rabbi shrah li sadri wa yassir li amri wahlul 'uqdatam min lisani yafqahu qawli. Assalamualaikum warahmatullahi wabarakatuh and selamat sejahtera Dr. Shanawi. Let me introduce myself. I am Asma binti Mat Nisa, matric number 2021356771. This presentation is actually to cater the case of law cybersecurity for my individual assignment for subject Industrial Relations, Regulation and Cybersecurity INC500. Okay, this case is related to the Computer Crime Act 1997. Too many parties involved in this case. First of all is Deputy Public Prosecutor versus Amar Asyraf bin Zolkepli as a defendant or respondent for this case. Public Islamic Bank Berhad as a third party. Messrs. Shahrizal and Co as intervener. Okay, reference for this case is C05573111/2018. Okay, today presentation I will cover facts of the case, issue of the case, judgment of the case, analysis and critique, and last but not least is reference that I use for this particular assignment. Yeah. Okay, let me explain to you the fact of the case. Okay, Amar Asyraf bin Zolkepli as a defendant in this case has purchased a software that enable to access the My IMMS services of Immigration Department. This particular software not only enable to access to the system but also can hack the information, can hack the information or bypass something. Okay, this system is actually to cater the application and approval for PAS pengkajian pengurusan pegawai dagang and PAS pengkajian pegawai dagang. What is it? These two PAS pengkajian pengurusan pegawai dagang is actually refer to the application of foreign worker. They want to come and work in Malaysia, they need to apply a permit, working permit, that need to apply. That's we call it as PAS pengkajian pengurusan pegawai dagang. And then secondly, after apply the PAS pengkajian pengurusan pegawai dagang, that system need to approve. That we call it as PAS pengkajian pegawai dagang. And then this actually related to application and approval of this particular foreign worker permit. Need to work in Malaysia, they need to apply the permit, and also the immigration need to approve the application. So this application, this software, Amar Asyraf has modified the software, and that particular software be able to bypass the biometric. So when the foreign worker apply the application, then after the immigration review and assess the application, that foreign worker will come to the immigration, will call that particular foreign worker or the agency to come to the immigration to put their thumbprint, or we call it biometric. What is the purpose for biometric? Biometric is to actually to manage the foreign worker in and out from Malaysia, come into Malaysia and go out, depart from Malaysia. That's the purpose of that particular My IMMS to manage the foreign worker in Malaysia. However, this Amar Asyraf bin Zolkepli, once he bypassed the biometric, he sold that particular software to the third party, which is the syndicate. This is illegal. So this syndicate use the software and bypass the system in terms of they apply through online, and then after that they themselves approve that particular application, because this particular system is able to bypass the biometric. Right, so this average transaction, Amar Asyraf can get 1,000 ringgit for every approval using the software. However, sepandai-pandai tumpang berlompat, akhirnya jatuh juga kan. So on 30th June 2016, Amar Asyraf bin Zolkepli has been arrested. Police, somehow dapat tangkap dia ni, and then he has been arrested and took to the court, High Court of Temerloh, for the offence of unauthorized modification of the content of any computer under Section 5 of Computer Crime Act 1997. And then as a Malaysian citizen, he has a right to appoint any lawyers, and he appoint appointed Mrs. Wan Shahrizal Ha and Co to defend himself, to help him to defend himself at the High Court of Temelung. And then during that particular session, the judge has decided that he found guilty and convicted not non-exceeding 100k or imprisonment in terms of not exceeding 7 years or to both. So actually this provision in this section 5 of Computer Crime Act, if I'm not mistaken, section 5/1, the provision in terms of penalty. If that particular found guilty or convicted guilty, so he is liable to fine not exceeding 100k or imprisonment in not exceeding 7 years, or the fine not exceeding 150k or imprisonment 10 years or to both. So this is the provision in the act. However, the judge decided that he fall under first category, not exceed 7 years, or and also need to pay the penalty 100k. In addition to the above, the prosecutor filed to the court that all the properties purchased by the respondent to be seized, to be disita under the Money Laundering, Anti-Terrorism Financing and Proceeds of Unlawful Activities Act 2001, Section 50/1, Section 51/1, and 56/1, and also 61(4)A Federal Constitution Article Section 5(3). Alright, apa benda yang prosecutor ordered to be seized respondent punya asset ni So prosecutor ordered to seize the respondent movable and non-movable asset that has withdrawn the attention of the third party. Let me explain to you the asset, the tangible and intangible. The tangible asset, intangible asset is money. Money that the saving account in the Genting Highland branch amounting 192k, almost 200k saving account dekat Genting Highland, Maybank Genting Highland branch. And then two saving account at public bank, first at the Taman Maluri branch at Taman Maluri, and second is PJ branch. Both accounts almost reaching 300k. The non-movable assets is property like apartment. He has apartment at Selayang, 1 unit R05036 is stipulated dalam jurnal tu. This is the address of the asset. And one car plate GRC 80, Audi model Audi S-Line TFS1, CVT automatic. So when the prosecutor ordered to seize the respondent movable and non-movable asset, has withdrawn the attention of the third parties. Who is the third parties in this case? First is Messrs. Wan Shahrizal Ha and Company. This Mrs. Wan Shahrizal Ha and Company and Co is actually the lawyer or the defendant lawyer on behalf of Amar, Asyraf and Zolkepli. So he mentioned that the Amar, Asyraf need to pay to him, them, almost 400k, the legal fee. This is the legal fee, 398k and 722 ringgit need to pay to the Mrs. Wan Shahrizal Ha and Company. Alright, so and then the second party is Public Islamic Bank Berhad. Public Islamic Bank Berhad is also the third party in this case, whereby the respondent actually pledged the property that he purchased from the unlawful activities to put at the bank as a cagaran for the fixed deposit. So Public Islamic Bank Berhad claimed that the property and fixed deposit account under guarantee. So he need to protect, the bank need to protect their punya interest. This actually the lawyer and the bank, they have a right, they think that they have a right to request to mencelah, to intervene to the Mahkamah Tinggi Temelung to request their right, the thing that the respondent need to, before the court ordered to seize the property, to seize the asset, they need the money from the asset to be liquid to pay the legal fee and also the bank guarantee for the fixed deposit of the respondent. Okay, let me see. Okay, this is the issue of the case. Let me, this is the chronological of event for this particular case. First phase is High Court Temerloh and second phase is Court of Appeal in Putrajaya. Let me explain to you. Prior to 30th June 2016, respondent purchased the software as I mentioned earlier, and then the system is actually hacked the My IMMS system of Immigration Department and provide the software to the party, and this respondent make a piece of it to make a profit 1,000 per successful transaction from the syndicate. And then 30th June 2016, he has been arrested and under Section 5 Committed Acts 1997, he found guilty due to modify the software to hack the immigration system. And 19 September 2016, Public Prosecutor issued a seizing order against the respondent properties purchased from the sources of unlawful activities. Because from the money that he obtained from the syndicate, he purchased the property, the Audi car and also the apartment and put also some of the money in the Maybank saving account and also public bank saving account. And also he cagarkan one of dia punya apartment tu to become a fixed deposit punya cagaran. Okay, so this prosecutor the prosecutor use the section 50 subsection 1 and section 51 subsection 1 of anti-money laundering, anti-terrorism financing and proceed of unlawful activities to seize the properties. Because this activity is dia buat something yang illegal, haram lah. You purchase the properties. Okay, and then what happened after that? In 12 July 2018, Messrs. Shahrizal Hari and Co. filed an appeal at Court of Appeal Putrajaya as an intervener. Actually, Public Bank also filed the appeal dekat Mahkamah Rayuan Putrajaya. What is the purpose? The purpose is to intervene and also to obtain respondent legal fee amounting 398,722 ringgit from the amount seized properties pursuant to the subsection 56(1) of the Anti-Money Laundering, Anti-Terrorism and Financing and Proceed of Unlawful. And then on 29 September 2020, the Putrajaya Court of Appeal allowed to hear the intervener appeal. Ada dua, satu Public Bank and satu lagi the Messrs. Shahrizal Hari and Co. Dua-dua ni appeal to get the part of the money from the properties yang seized to pay dia punya legal fee and also the minta balik cagaran of the fixed deposit. So the issue is it possible that asset purchased from the unlawful activities can be used to pay the respondent legal fee to legal firm? This is the issue. Okay, what is the judgment of the case for this particular case? On 28 January 2021, the Mahkamah Rayuan Putrajaya order, the judges decided that the respondent legal fees cannot be paid from his seized properties and the interveners has no legitimate legal interest in the property. That's the keyword. Consequently, the intervener cannot be considered as bona fide third party under the Act. So, what is the counsel right? Apa benda sebenarnya right yang ada pada lawyer ni ataupun intervener? On the issue of the respondent's right to counsel, the judges of the appeal court agreed that this right is guaranteed under the Federal Constitution as provided under Article 5(3). So the counsel right, dia masih ada lagi hak dia untuk menuntut apa-apa yang masih tertunggak kepada respondent. However, the fact that the payment of legal fees cannot be made from the seized property, it is not the door stopper for the counsel to obtain dia punya legal fee. dia ada cara lain lagi dia nak get the money ya. Okay, this is the analysis of critics. Okay, for the third party, if you are the third party or intervener for the case, legal fees of counsel representing a client cannot be paid from property that has been seized under section 51, section 50, subsection 1, 51, subsection 1 of the Anti-Money Laundering, Anti-Terrorism Financing and Proceed of Unlawful Activities Act 2021. Okay, because of the scheme and purpose of the act is to prevent money laundering and to facilitate forfeiture of proceed from any unlawful activities. This include preventing any person or body from obtaining any benefit from the proceed of the law. Dah haram-haram lah tak boleh nak you bersihkan lagi duit tu lagi sebab dia datang dari sumber yang haram. However, all is not lost as counsel may seek resources and claim for unpaid legal fees under the client solicitor contract if judgment has been obtained against the client for the payment of legal fees. Dalam this case, if you were the third party before proceeding the case, please ensure that your client has enough money to pay your legal fee. Because you're not doing the pro bono case. You make a money. You are a lawyer, then your company needs to survive. So make sure that your client has enough money to pay you. And then as a critique for this particular case is pertaining to the Competition Act 1997. The act is too lenient. The act is too lenient because of the respondent. Amar Asyraf bin Zolkepli make a lot of money from the syndicate. Bayangkan satu transaction he managed to obtain RM1,000. Kalau 30 orang dah 30,000. So this is the case that might be the government need to review back the punishment. And then the imprisonment also minimum 7 years, maximum 10 years. Boleh dia keluar kalau dia pandai komputer, kalau dia pandai teknologi, dia boleh hack balik semula. Okay, because of we living in nowadays, we living in digital age. Everybody just click here, click there, and then everything is now online, especially during the PKP. And then if someone, the system of government system, in particular immigration, especially during this pandemic COVID-19, kalaulah tak ada betul-betul law yang really protect the environment, the ecosystem, someone yang clever or really IT savvy, they can hack the system. And then can you imagine that foreigner can come without quarantine dekat Malaysia ni. Can you imagine now is the pandemic. This is one of the what we call it, to curb the misuse of the system. So the law actually one of the civilized nation, we need to have a law. Okay, for the record, the Amar Asyraf bin Zolkepli or in this case is respondent has been released from the jail on 28 January 2021. Can you imagine? Dia buat kerja 2016, 2021 Januari dah keluar. So sangat-sangat lenient this Competition Act punya penalty need to be reviewed lah. Okay lah, this presentation is just present lah to reveal my critique and opinion. I understand. Sebab sekarang ni pun parlimen tidak bersidang, sebab kita dalam tempoh darurat. So this presentation to you, Dr. Shanawi, just this my opinion. Bukanlah I nak challenge sebab sekarang ni I understand kita tengah darurat. Alright, this is my reference for this particular assignment. Okay, last but not least, thank you for your time. Thank you for listening. Okay, thank you. Bye.